Welcome to another episode of Friends of the Court, Law Made Easy. I'm your host, Ian Snow, with co-host George Bassias and our special guest, Michael Delakas, Esquire. Welcome, Michael. Thank you for coming to the program.
Thanks for having me.
Please tell us a bit about yourself and the areas of law that you practice in.
I've been practicing for about 10 years now. I focus on workers' comp with George sometimes, criminal and family law matters. That's pretty much it.
Criminal and family matters as well?
They intertwine.
Okay.
Because sometimes you might have a family law issue, and because violence was used, then it becomes a criminal law issue, order of protections, so they're kind of intertwined. There's different courtrooms, but sometimes they're intertwined.
And how can people get in contact with you?
My phone number is 212-321-0232.
All right. And where is your office?
In Astoria, on Steinway Street.
Okay. And do you have a website or social media presence?
mad911.com.
Now, I did notice on your website that you also practice in the area of estate planning and divorce custody issues, correct?
Well, the custody and divorce kind of fall into family law, even though divorces are basically in Supreme Court. But because there's custody issues and support issues, sometimes when the divorce is over, people have to petition the family court to get an order enforced based on whatever the Supreme Court says.
George, would you like to add anything?
Yeah, there's a couple of things. This particular segment will focus in on criminal law, on driving while intoxicated and driving while under the influence. Michael has a double whammy of experience in the area of criminal law. What I mean by that is a former retired police officer for the NYPD, detective, and he's a specialist in criminal law. One of the things I'd like to say, I'm a licensed attorney in the state of New York. Michael is a licensed attorney in the state of New York. And what we will be discussing today, we're discussing generally. If you have a particular situation that involves the area of discussion that we're in, our advice is to you to get your own counsel, because every case is different in its own specificity. There are things that are in your case that may not apply to the general discussion that we're having. So my advice to you is either hire your own lawyer or get a lawyer appointed by the court at no charge for you to represent you. Do not try to figure out by yourself. You're taking a big chance. Every now and then I get people coming, telling me about medical issues, what they learned on the internet. You can't do the same thing with law. You just can't. You have to be an attorney to understand how the system works. So our advice is get your own attorney, but please enjoy the segment on this discussion on driving under the influence and driving while intoxicated.
Yeah, and to continue with that, George, driving while intoxicated or having an accident while after having had a few drinks happens to the best of people. And even in the news recently, the husband of the Speaker of the House recently was arrested for DWI in the Napa Valley in California. So it can happen to anybody. Michael, could you please tell the listeners the difference between a DWAI charge and a DUI charge?
So there's a statutory where if the breathalyzer says that you're 0.08 or above, you are driving while intoxicated. Anything below 0.08 could be driving while ability impaired. I believe it's up to 0.05 to 0.07.9 or something to that effect.
I see. So it's a matter of alcohol content with the breathalyzer.
Yes, but however, DWAI is a violation of the penal law. It is not a crime. So you would still get arrested. You would still have to answer in court. You'd still have to oblige by what the court tells you. However, the end would be no conviction of a crime. So a lot of people, when they apply for jobs, have you ever been convicted, would be a no. However, DWI, it is a misdemeanor. So if you get convicted of a misdemeanor, usually it's a misdemeanor, it's a crime on your record. And New York doesn't recognize, expunging of records.
Wow, so it's a permanently on the record these days.
Pretty much. I mean, there's other ways you can get something called disability of in other words, that you're kind of showing the court that, okay, you know what, I made a mistake, but I'm a good guy now, so the court will give you like another chance. But that doesn't mean that the conviction will be taken off.
Yeah. So we've put together some questionnaires from listeners and ourselves. I'll go to our second one. So George, did you want to add anything to what Michael said?
So, assuming somebody is a first-time offender, which is the higher charge, the DWI? The misdemeanor charge?
It depends.
Okay.
So it depends on what happens at the inception of the police stopping you, and then what happens subsequently, getting the breathalyzer later.
Okay.
So there can be a situation where, you don't, the officer looks at you and he believes you're intoxicated, and it could be bloodshot eyes, slurred speech, unsteady on its feet, and that's basically the common law.
So if I called you, Michael, if I called you from the scene, I just got pulled over, I just left the bar, and I know I was intoxicated. The cop asked me for my driver's license registration, and I could tell by the way he looks at me, he can clearly tell that I'm drunk. He even asked me if I've been drinking, and I don't answer him. And he goes back to his vehicle, and while he's in his vehicle, I make a quick call to you, and I say, Michael, I'm in trouble. I just got pulled over. I'm really drunk. The police officer can tell that I'm drunk. I think he's going to ask me to do a breathalyzer. What do I do?
All right, that's a very loaded question. Because it all depends on the facts. So let's say you did mention something earlier. Let's say you get into an accident, okay? And let's say you hurt somebody or you kill somebody. I wouldn't take the breathalyzer because you're just giving the state more evidence against you. Because you already have the aggravated DWI because you injured somebody, or worst case scenario, God forbid, you killed them. So you're just basically giving the state more evidence if you breathalyze. Now, would you say do you blow? Is that the question?
Yes. Do I
Okay.
blow?
It depends again. So if you have a CDL, if you have some sort of, if you're a taxi cab driver and you need to drive, if you don't blow, you would get your license suspended for 90 days, right off the top. That also is a problem, like in Nassau County, because Nassau County doesn't negotiate well if you refuse, because the mentality is that driving is a privilege and that you're subject to the breathalyzer. And if you don't breathe, blow into the breathalyzer, they're very resistant to give you a DWI, which is a violation, even if it's your first time arrested. All right, so there's hearings involved in a trial, and they could find you guilty. Some other jurisdictions are different, but you never know. So
What about in Queens?
Queens it varies in Queens too, because again, if you don't blow and provide a reading to the police officer, it depends. Sometimes I can't give you a definitive answer because it depends also on the circumstance of the case, and the district attorney may say, no, we're not doing it, we have to go to a trial.
It sounds to me from what you're saying, if I have a clean record, I'm better off blowing.
Yeah, but I can't tell anybody to do that. So, if you've never been arrested before, but you're also taking the risk too, because if you had 10 drinks and you blow it, 2, not a 0.08 or 0.01 or even a 1, but like double. Sometimes it's aggravated DWI, and then you have more problems. So, I mean, if you had 3 drinks, it also depends on your body too, because I did something called a drinking lab when I worked in the Miami-Dade State Attorney's Office, and basically they allow you to drink, and the new police officers do the tests on you, and I realized that I burn the alcohol fast. So when I blew really high, when they tested me again, I came really low. but I failed the coordination test. And I don't think I failed that much, but, you know, the police officer thought I failed, and so that's what he wrote down, that I failed.
Interesting.
And that is his probable cause, which is needed to arrest me.
Interesting.
Something you said also makes me think in some situations it would be better not to take the test and not just hand over that immediately to the state. What happens if somebody lies and says, I didn't have more than 2 drinks, and later on they find out from a receipt at a bar that they had 6 or 7? Would that work against you in the court that you lied?
Okay, so those are rules of evidence, okay? And the rules of evidence allows extrinsic evidence against you to impeach you, in other words, catch you in a lie. So we're talking at the trial level, all right? But I think everybody's seen enough movies when they tell you, if the police talk to you, don't say anything, right? I think that's a common thing. But people, I think, is just, you know, general in nature. When they get stopped and they feel like they didn't do anything wrong, they want to explain themselves. But sometimes explaining yourself is, you know, admitting to things. So if you don't say anything, they have nothing to hold against you. I mean, you're required to give your name, you know, where you live, your date of birth, things like that, you know, identification stuff. But other than what happens, you know, they don't. Now, there's also the issue of Miranda. So Miranda has, you know, there's 2 issues. So you have to be in custody and asked incriminating criminal questions. So if the officer does give you Miranda, anything afterwards would be held against you. But that doesn't mean that you have the right to remain silent. That's the first rule in Miranda. You have the right to remain silent.
You're watching Live1.tv with attorneys George Bassias and special guest Michael Delakas. Don't forget to subscribe to Live1.tv, where you can find more great programming.
You know, when you ask me about the Miranda warnings, you know, you have the right to remain silent, you have the right to an attorney. If one can't be afforded to you, you know, one will be provided to you. Anything that you say, well, I skipped it. It's a right to remain silent. Anything you say will be held against you. And actually, you know, there's a card where you have to read from. And for you to waive your Miranda rights, you have to do it knowingly and voluntarily. Now, what's great about New York, if you do want to waive it after the Miranda's been given to you, you need an attorney present to waive it. So that's a good thing. So even if they ask you any questions after you waive Miranda in New York, you need your attorney to do so. And all those statements will be held against you.
That's very interesting. Let me ask you, Michael, I've seen TV shows where, like Law and Order or something, they almost make it a bad thing to ask for a lawyer. They're like, you better tell us everything that's happened, or do we have to get the lawyers involved? And TV tries to depict it like, once you ask a lawyer, then you're going to have a problem. It's going to be a very expensive proposition. How accessible are free lawyers for individuals that can't afford it?
Okay, so in you know, in the boroughs that I've worked in, there's legal aid, and there's something called 18B. So legal aid takes people who can't afford a lawyer, and you're entitled to a lawyer, you know, provided by the Sixth Amendment, from any critical stage of, you know, after you've been seen by a judge and been arraigned. First time seeing a judge, anything afterwards. So now, if there's a conflict, so let's say you have 2 people that know each other, and you know they've cross-claimed against each other. So legal aid can't take both. So legal aid will take one, and then 18B are private attorneys only that take conflict cases. So they would be, and they're basically contractors to the city or to the state, excuse me, and they would defend that person. So there's no conflict.
All right, so basically, because this is law made easy, and if this is being watched by somebody who doesn't understand the intricacies of the legal system, the proper advice here is, if you're pulled over by a cop, do not give any confessions, be quiet, speak to a lawyer first, ask for a lawyer.
Any statement.
Do not make any statements whatsoever without a lawyer present. Ask for a lawyer, even if you can't offend one. Are the lawyers that are provided by legal aid and 18B, are they good lawyers?
I think that they are, because they are handed down, they have 100 cases. The only difference with legal aid and private attorneys is that legal aid, because of all the caseload, that they're overworked. So they can't be available to their client as much as a private attorney can. And that's basically, you're paying for a private attorney to guide you through the system.
Right.
Now, under the Sixth Amendment, you have a right to counsel. So legal aid will be there. And like I said, legal aid would not do anything, nefarious or anything. And I believe that they're very good because they get exposed to a lot.
Got it.
And, also, think about it. You're in court every day. You see the same judges, you see the same district attorneys. You're able to have more communication.
They're connected.
Yeah.
Basically.
However, there's certain boroughs that will, they have to ask you, because sometimes, I know in Staten Island, they ask for W-2s to see if you can or cannot afford an attorney. I don't know the threshold of the amount, but that does happen sometimes.
Oh, interesting. I didn't know that. Let me ask you one real quick one, then I'll pass the mic to Ian. This is a true situation. When I first became an attorney, I actually got admitted in the state of Connecticut before I did in the state of New York. I had absolutely no experience in law other than knowing what I learned in law school. I never did any type of clerkship, never worked for a law firm. And my father owned a diner, and I wound up representing one of the cooks who got arrested for DWI in the state of Connecticut. Now, the breathalyzer test, it seemed like one test showed that he was intoxicated, but they took a second test and it showed that he wasn't intoxicated. But at the same time, he told the police officer, look, I'm not drunk, I wasn't drinking, but I was smoking pot. So the prosecutor proceeded. I remember his name was Esposito. That's all I remember. You're talking about 30 years ago. Guy's name was Esposito. And this case actually got on the trial calendar. At the end of the case, I wound up settling it. We pled guilty to a parking ticket. But my position, even though I had no experience in law, was your breathalyzer test is defective, and you cannot convict somebody on their statement. You never did a blood test. You don't know if he actually was on drugs. Was I right, or did I get lucky?
So you could be, you could be smoking, a whole thing of marijuana, and you will not fail a breathalyzer, because the breathalyzer checks for alcohol content inside the blood. And when you breathe out, it's a connection. With marijuana, there's no alcohol, so the breathalyzer doesn't record it. However, there are things so a police officer, especially the highway cops, they're probably, because they do more, car stops. They're called drug recognition officers, but I'm not sure if I got the term right. But basically, they do extra training to see if somebody is, impaired, would be the legal term, other than marijuana, other than alcohol. And they do certain tests. Additionally, if I could always take it to the hospital. Right now, you can, and this follows the same thing. You can refuse, but we spoke about the refusal. If you refuse, the consequence that you got to deal with. So.
Did I get lucky?
A parking ticket? Yeah, that's great.
A lot of praying.
No, that's good. But you never know what kind of case that the district attorney has.
Right.
So, until the things, because every case is different.
Sure. That's why everybody needs to have their own lawyer.
Yeah, it's like a safari guide.
We mentioned at the beginning of the program DUI, driving under the influence. Is that?
So New York DWI, DUI are kind of interchangeable.
Right, that's what I'm wondering.
Yeah, the law states DWI, which is driving while intoxicated. And then there's different levels, of course, because let's say somebody has a conviction of already a DWI. Now they're looking at felonies. depending on the aggravated, facts of their second case.
If it's a second time, they're being prosecuted for a second time, it's now as a felony.
Well, it depends, because it depends on the, like I said, I mean, if you've already been convicted of the crime of the DWI and you get rearrested, I believe it's 3 times, but I'm not really sure. And it also depends on the facts of the case, because I think a 3-time, if you get caught for the 3rd time and you get convicted, the DMV, and now there's a difference because now the court can't suspend your license, but DMV is going to. So there's 2 different systems. You got the criminal justice system here, and you got the DMV here. The DMV charges with your license stuff, but they follow the courts. So if you do get your license suspended or revoked, it's a DMV judge, which they're administrative judges, the ones that make the decision on that. But if you already have 3, convictions, there's not a good chance you're going to get your license back.
Can you tell the listeners the difference between the consequence of a misdemeanor versus a felony?
By definition, a felony is any crime that has a conviction of over a year. A misdemeanor is anything less than a year.
Okay. And how do the respective courts, Nassau versus Queens or Bronx, treat somebody who's a first-time offender?
Again, and I think I mentioned it before, if you refuse the breathalyzer in Nassau County, they're very resistant to negotiate with you.
I'm sorry, I don't mean to interrupt, but let's assume you did the breathalyzer and you are intoxicated. How does Queens or Bronx or Brooklyn versus Nassau County treat you in the plea bargaining system when you have a clean record?
Okay, so you mentioned something earlier. This can happen to anybody. Okay, so it can happen. It just happened to Pelosi's husband, right?
Yeah.
You never know. You go out for the weekend, you have more than 1 drink, you never know. It depends on the facts. So let's say you blew a .05, okay? It's on the borderline being impaired, right? What I do with clients is I first have them evaluated with a drug counselor. So because it can happen to anybody, when you have them evaluated by somebody trained, you're giving the court now and the district attorney that this person does not have a drinking problem. This was a one-time deal, all right? There's programs involved. I just changed the name of it, I forgot, where you have to do like a program, basically the issues of driving while intoxicated. And on completion of that, there's a good chance that the district attorney will give you a violation and not a crime.
Right.
And what if it's greater than a .5, like .8?
Again, if it's your first time, like I said, you try to get the person evaluated, and sometimes, they may not have to go, if they do have a problem, you're basically trying to show the court, because the court is the one that does the sentencing, and, the judge. So you're trying to show the court, I got a problem, I made a mistake, and I'm trying to take care of my problem. The judges are not going to hammer you if you're trying to take care of your issue. That is, if you have a problem.
Michael, could you tell our listeners what happens if somebody is pulled over driving their car and an officer asks them to roll down their window and suspects that they've been drinking, and the person says, I haven't been drinking anything, I only smoked a joint? Can a prosecutor proceed on that statement, I was only smoking a joint?
Well, remember we discussed earlier about the rules of evidence in Miranda?
Yeah.
So when an officer, reasonable inquiry, can ask you a question and you answer in the affirmative, you answer me. Can that statement be held against you?
I guess it can be, yeah. And they could be prosecuted for just saying, I didn't have any alcohol, I had not a beer or not anything else, I only smoked a joint. And
well, see, the thing is, when you go to trial, there'll be a hearing on the statement. And, basically the prosecutor has to prove that was, it could either be an excited utterance, which is an exception to the hearsay rule, present state and there's different, I don't want to list them all now, but especially the minute you say something without being Miranda-ized, having Miranda rights read to you, those statements are nice and open. If you say, I do not want to answer any questions. Now, some people think, oh, what's your name? Oh, I don't have to answer. That's not necessarily true. You got to give the officer your name, where you live, date of birth. That's all fine, because none of that's all for ID. None of that would be considered an incriminating statement.
But in that question that Ian asked,
Oh,
other
I didn't
than
answer.
your,
I missed it. I'm sorry.
I'm not talking about, whether it's proper to remain silent or to speak. In the event, you could have somebody that's a compulsive liar. There are people that make things up that aren't true. Doesn't the prosecutor have to constitutionally prove that other than that statement, there's some other objective evidence of intoxication in the situation where somebody says, I smoked a joint? What if they didn't smoke a joint? What if this person's a compulsive liar?
So there's a standard of proof. So the prosecutor has to prove a crime beyond a reasonable doubt. Okay? And for the affirmative defenses, depending on the jurisdiction, of course, the defendant would either have a preponderance of evidence to prove an affirmative defense, such as insanity, which you're kind of talking about, or clear convincing evidence, depending on which court, and different jurisdictions. I don't quote me on where it is, but the one rule I know is that the district attorney has to prove beyond a reasonable doubt that this person, more than, the definition of probable cause is that it's reasonably more not probable that the person committed the crime accused of. So it's on the burden of the state. So if you said a statement, do you think the prosecutor is going to use it? Probably.
But they would also use it, though, if on the police vehicle there was a camera showing erratic driving put together with that kind of statement, perhaps.
Well, so what happens is now, police officers have a body cam, right? And there's certain situations that they have to turn it on. When you're doing a car stop, you have to turn it on, right? Some cars have the car cams, but let's talk about this. So now there is, and a police officer will tell you, you're being recorded. Some will do, but usually when you look at the body cams, there's a red. It's black, but there's a red, blinking.
Yeah.
All right, and when you turn it on, there's a loud beep, so you know you're being recorded.
Yeah.
That's good and bad because, but how can they prove anything to you when, I don't want to answer any questions and here's my information.
Yeah. Silence is
'Cause
golden.
You can't smell alcohol on a camera.
Right.
Now, but see, and I think if I wasn't clear before, so there's two levels here. When you get pulled over, right, you got to get pulled. The police officer has to have probable cause. So a lot of people get pulled over because they ran a red light. Because the classic is that they changed lanes without signaling, or a double yellow line they crossed over, which is a violation. So the police officer does have a probable cause on the traffic infraction. So then when he approaches you, he can make an assessment, again, based on, smell of alcohol, slurred speech, bloodshot eyes, and now that gives him a level now that there might be DWI, all right? So depending on the jurisdiction, sometimes they'll give you the breathalyzer, which is the easy way to test, but it's not very accurate. So because those are used all the time, so the level of, and especially when you're court, you want to have the best evidence. Those really are not, but it gives, the officer probable cause to arrest you. So now you're under arrest, right? And you go back to the precinct. Now there is another test, which is more precise, all right? And I know in Nassau County, they only film the refusals. I don't know if it's changed. The last one I had, that's what it was. And New York, they call the highway unit to come and they'll videotape you. And those guys are trained to just do that, all right? So any kind of a testing that's done is videotaped.
Yeah.
Yeah, so did that answer your question?
Yeah, it does, and it's an interesting thing. So I didn't know that certain law enforcement units have two sets of equipment that can detect alcohol content. One that maybe is in a car and one back at a precinct that would be more sophisticated.
Yeah.
Wow. Thank you.
And I had a mentor that actually had the machine in his office. he knew that machine inside and out.
Yeah.
Because there's a whole bunch of science involved with how the machine, when you breathe, because there's a way you're supposed to breathe. You're supposed to breathe for a certain amount of seconds. Now, let's say, especially with COVID, everybody washing their hands with alcohol, right? Sometimes that throws the machine off. And if you're getting accused of a crime, you need to have the best evidence used against you. So,
Do you know what one of the deputy police commissioners of New York once told me? When they're trying to figure out whether there's radioactive material being transported in trucks, potentially a dirty bomb, he said that cartons and crates of bananas will set off their equipment, that bananas actually have something that will set off the same type of detection equipment. And you're saying that if somebody's used some kind of rubbing alcohol or some of this sanitizer, it potentially could also affect the reading.
Interesting.
Yeah. Hey, tell me something, Michael. I know that we've seen on television shows the DUI types of tests where, in addition to blowing, somebody will get out of the car and, try to touch their nose, walk in a straight line. Have they developed a separate set of tests for marijuana or hashish or people on other types of drugs?
so those are coordination tests. Nassau County does them on the street, and I don't know if things have changed in New York City. I haven't had one for a while. Because of the traffic we have, it is safer for somebody to do the coordination test back in the precinct. And there's something called an nystagmus test. So you ever see on video where they take a pen and they do this?
I have seen that.
Okay, so basically you're focusing on the pen, and as you're drifting while you're looking, the eyeball does this. You can't control that. That's that is one of the signs of alcohol. And usually, I don't know if it's drugs does that, but I know alcohol does. So you can really tell, because if you look, and I think the idea is that your eye is trying to focus, but because you're intoxicated, it starts doing this. And it's very obvious.
Yeah.
Yeah, and you could YouTube nystagmus and you'll see it, how obvious it is.
Wow. And that together with an officer's camera, it might all end up in the court.
I mean, the end, you go to a trial and the burden's on the state for them to prove their case beyond a reasonable doubt.
I'm sorry?
I mean, if you really want to fight a DWI, you go to trial.
Yeah.
And the trial, the state has to prove beyond a reasonable doubt, which is a high burden.
Right.
So,
Because that's a criminal case with the highest level of burden.
Yes.
It's not civil. Right.
yeah, I mean, there's preponderance of evidence, clear and convincing, but for a criminal case, it's beyond a reasonable doubt.
George, would you like to add something?
And just because this show is law made easy, this trial will be held. The trial will,
complicated, sorry.
yeah, the trial will be held in front of a judge, and how many jurors?
So, again, it's statutory. So federally, you're allowed a minimum of 6, maximum of 12, and you need a unanimous vote. It depends on what you guys agree to, because you can agree to a non-unanimous jury.
You said federally, but most of these cases are state cases, correct?
Yeah, I know in Nassau County it's 6, I've seen 12, but it all depends. I mean, I haven't been throughout the, and then there's something called a bench trial, where it's up to the judge who's the fact finder, and he's the one that, now you're putting it on just one person compared to a jury who has a right to deliberate, and the higher burden of proof on the state for them to prove beyond a reasonable doubt.
Okay.
I think I've had a great time here with you, Michael, learning a lot to think about, and I hope you'll come back here soon. George, would you like to follow up?
No, I did too. It was very interesting. So, just in conclusion, so we get it straight, basic advice is if you're pulled over by a police officer and it's a big accident, you probably, if you have a chance to call an attorney at the scene, call the attorney and remain silent. Do not give any information until you speak to your lawyer, regardless of whether it's a heavy accident or not. And if you can't speak to your lawyer, first time offense, there's no accident involved, it seems like the best advice is take the breathalyzer and then talk to your attorney. But always ask for an attorney. Don't give any statements to the police.
And we'll do a question. Ari, you have a question?
Yes.
We have another question put to us, Michael. Suppose that you haven't been drinking, but you knowingly get into a vehicle with somebody that has been. They end up in a car accident. Is there any liability that can fall on the person who was a passenger in the car?
All right, so it's kind of hard to answer because you use the word liability. So this could be a tort question, which is the negligence, okay? So if somebody is driving while intoxicated and they are negligent in that, the passenger, if they get hurt, they can have a suit for damages against the driver. Especially, and it's kind of easier too, because, you know, if the person pleads to a crime, that's considered a record of evidence, and that's all you pretty much need for your legal suit. But remember I discussed before about criminal and civil? Okay, so criminally, you're a passenger. What are they gonna do to you?
Mm-hmm.
But civilly, you would have but you have to have damages to have a lawsuit.
And maybe you should have told them don't drive, knowing that they had 4 drinks at the bar, but you got in the car with them anyway.
Yeah, there's something called a dram shop rule, where sometimes the host of the party, but that's a civil thing.
Mm-hmm.
I wasn't here to discuss those kind of things. I was here mostly criminal, right? So I wanted to,
All right.
I do want to add something that I've seen, kind of a trend, if that's okay.
Please.
So the law states that to show that you're driving, you need to be behind the wheel, the car running, and the key in the ignition. Okay? So let's say you're parked. And a lot of people, I'm just going to sit behind the car cold so I can warm up in my car, and I'll just wait till I sober up, and then I'll drive. I know a lot of people have done it. However, if the police come up to you and they believe that you're drunk in that situation, do you think you can I'm going to ask you, do you think you get arrested?
If that car is turned on, I would say it meets the definition that you just provided. The key in the ignition and the car is running.
I've seen people get arrested for that alone. And their intent was, I've had a few, but we live in New York, it's cold, especially in winter. So you want to be warm up. So, let me just get in the car, warm up, and I'll be okay, and then I'll drive. Mm-hmm. But during that process, if the police, if you give attention to the police and they realize that you're intoxicated, that's all they need. It happens more often than not.
Yeah.
So what would you do? That's the next question.
That makes sense to me, but just to make it clear for the question in the audience, I think the answer is no. As a passenger, you're not responsible for the drunk driving. You actually can have a claim against the drunk driver. It would be impossible, almost impossible, for a prosecution to go after you unless if you gave a loud confession saying, I knew he was drunk when he got in the car.
No, actually, no.
Right?
No. So to have a crime, you need the mens rea, which is the intent, and then you have the actus reus, which is the act. So being a passenger in the vehicle, there's no intent there.
There's no intent, exactly.
So you can't be charged.
But the answer is no.
No.
No, okay.
I mean, I touched
We
on
could
the
explain
civil.
it a number of different ways, but the bottom line is no.
Yeah.
You're the victim when you're in the car
Yeah.
with a drunk driver. And if something happens, you have a claim against the driver of the vehicle.
Now, if that person has a child in the car, there could be, a child abuse claim now on top of it because you're negligently driving intoxicated with a child in the car.
Yeah.
And might up the charge.
Michael, we have a question here which I think is a good one. Suppose somebody's cutting the grass and sitting on their John Deere lawnmower and they've had a few drinks and an officer comes up to them.
Okay, again, a police officer needs probable cause. They can't just come up to you without probable cause.
Yeah.
So let's say you're driving the lawnmower on the street where it's not allowed, that's probable cause. Now, I think the issue would rest if the lawnmower is considered a vehicle for under the penal law. So to answer that question, I wouldn't know until I knew. I can't define the lawnmower as a vehicle, you know, the top of my head right now. But, you know, again, if they have probable cause to pull you over if you drive, you know, no, there's there's different issues now because this person is driving on, you know, on their property. It might be okay, but again, that's why you go to trial, because now you have to figure out how do they get probable cause to pull you over? How do they get probable cause to think that you're intoxicated? Did you breathless? See, so there's a lot of variables to finally arrest you.
I think it's safe to say that if somebody's intoxicated on a lawnmower and they're mowing the lawn on the curb, which actually belongs to the city, and the public has an easement on it, and the officer sees it in plain sight, yes, he can arrest you because now you're a danger to the public. But if the officer comes in your backyard and sees that you're drunk, he's just violated the Fourth Amendment. You know, unreasonable search and seizures, what goes on in your house is very private. So he'd have to deal with that issue. You'd probably get that thrown out.
And this has been a great reminder that we live in a nation filled with laws, and the more that we understand them, the better off we and our family and friends can be. Thank you again, Michael, for coming today. It's been a
My pleasure.
Thank you.
I hope I could help. So.
We hope you come back soon. Bye-bye now.
Thank you.
Bye.